Everybody. I'd like to welcome everybody this evening. My name is ALYSSA. I am the president of the New York City Lera, and I'm very excited about tonight's program. It's the title, When Home Becomes the New Workplace, Employee Discipline, Privacy and Other Issues. I think it's going to be a very interesting discussion this evening, and certainly if it's as interesting as our pre-discussion, I think you're all going to find out a lot of good information this evening. A little bit of housekeeping before we start. If you want CLE for tonight's program, please provide your email in the chat. I will get a list of that after the program tonight, and I will email you the forms that you need. I will also be giving 2 codes this evening. I am only allowed to say those codes twice, and I am not allowed to put them in the chat. So please make sure you pay attention when I give the codes for the program this evening. And I believe Bernadette mentioned if you don't have your correct name on the Zoom, you may want to correct that so we have that also for the CLE. So I would like to start out this evening by introducing our speakers. We have moderating the program tonight, arbitrator Elena Cacavas. Elena has served as an administrative law judge with the Public Employment Relations Board, and she is currently an arbitrator and a AAA arbitrator. She had jurisdiction in PERB over Long Island, New York City, and Westchester, and she has extensive experience in all aspects of public sector labor relations, including adjudication and mediated resolutions of improper practice charges and bargaining impasses. She's actually presided over more than 1,000 cases and issued over 500 decisions addressing topics such as discrimination and retaliation, unlawful discharge and or discipline, refusal to bargain, past practice, unilateral change, the duty of fair representation, mandatory and non-mandatory subjects of bargaining, and the list goes on from there. Joining Elena is ALYSSA ZUCKERMAN. ALYSSA is a partner at Lamb Barnosky, and her practice focuses on representing employees in both the public and private sectors in labor, employment, and education law matters. She has experience in public and private sector collective bargaining, grievance arbitrations, interest arbitrations, employee disciplinary proceedings, unemployment insurance hearings, and matters before the New York State Public Employment Relations Board and the NLRB. And last and not least, Seth Greenberg. Seth is a partner at Greenberg, Boscelli, and Greenberg. He represents labor unions and employees in their health and welfare funds and in a wide range of labor and employment law matters, including collective bargaining, discipline and discharge, discrimination, wage and hour issues, contract disputes, seniority, and promotion. So without further ado, I'm going to hand everything over to Elena.
Okay, thank you, Anne, for the introduction, and thank you, ALYSSA and Seth, for joining me on this panel, and thank all of you who will be spending the next hour and a half with us. So, you know, it goes without stating that COVID brought upon all of us just seismic changes in how we go through life and certainly how we conduct business in this country. It came upon us so quickly and we really didn't have time to prepare for it. So we're still going through the motions. But one of the things that developed, which is really quite fascinating in terms of the rapidity with which it came into being, is working remotely. And so we're going to talk today about that, and particularly issues relating to discipline and privacy concerns in that context. So I just want to begin by taking about 10 minutes to frame the discussion and share with you some interesting statistics. And then we're going to hear from Seth about the issues that are important to labor in this regard, and then from ALYSSA about management's perspective. So before COVID, just about 3.6% of US workers regularly worked from home. Those numbers increased quite dramatically in the spring of 2020 and continued to increase over the course of the past 2 years. And they're likely to continue to some extent, although we don't know what extent that is. Now, the change meant that we were shifting from traditionally measuring employee accountability largely by bodies in seats to looking at other factors. We miss that bodies in seat calculation when we're dealing in a remote context to a large degree. I gave a speech in October in Saratoga, New York, to a relatively large crowd. And I asked a question which had an interesting outcome. My question was, if you have an employee who has remained as productive working at home, and you can measure that productivity, but he's been going around telling people that he loves working from home because he's able to get to the gym for the classes he likes for 2 hours in the afternoon. Do you have a problem with that? Well, the response was almost to a person separated by age. So the people in the audience who looked to be 50 or older said they had a problem with it. And the younger people in the audience said, well, no, if they're getting their work done, who cares when they're doing it or where they're doing it? Underlying the discussion that followed were issues of trust and accountability, which really go to the core of this whole shift to remote working. One of the biggest holdbacks of remote work is trusting employees to work untethered to a large degree. Again, we're shifting from counting occupied seats rather than just results. Now, certainly, as you can imagine, that's been accompanied by the emergence of spyware. And, it's also called tattleware in the industry. It raises the question of, is it snooping or is it reasonable oversight? And I have a feeling that ALYSSA and Seth would have different opinions on that. In April of 2020, Google inquiries for remote monitoring increased 212% from April of 2019. And in April of 2021, that surged by another 243%. And by January of 2022, as employers have been pressured to continue some form of work from home, it increased again by more than 200%. So what can that technology do for employers? Well, it can track emails and Google searches. It can give attention tracking alerts to hosts when a meeting participant is focused away for more than 30 seconds. It can provide a live feed for an employer. And it can send periodic screenshots to an employer. Now, there was a survey by software maker Atlas VPN, which said that monitoring a single remote employee costs about $7 a month. Now, remember that figure, because in a few minutes, we're going to talk about what the savings is projected for employers. The general rule, of course, is you cannot spy on employees at home. And that's unless you're using company-owned equipment, there's notice and consent, and there's a company network being used. But keep in mind, those were the rules when 3.6% of employees regularly worked from home. So question what changes we're going to see in restrictions in terms of monitoring in the context of the home environment. The issue is, of course, privacy in what is no longer completely a private setting. And isn't that interesting? We can all agree that employees historically have not had many privacy rights in this country. Courts have generally supported the view that if you work on company equipment, your data belongs to the employer. That premise was based on the Electronic Communications Act of 1986, which, keep in mind, was created before desktop computers were even commonplace. Now, in the employer's workplace, employers generally can monitor most areas so long as there is a legitimate business reason for doing so, which would outweigh privacy interests. And that's a pretty low threshold to meet. Notice is required to the employees, and that can be met by having cameras in visible areas. And New York has historically prohibited surveillance where an individual has a reasonable expectation of complete privacy. So that has traditionally applied to bathrooms, for example. Well, what happens when the employee is working in his or her bedroom or working in a studio apartment where the bed is in full view or perhaps directly next to a desk? There are also Fourth Amendment implications, which I think Seth and ALYSSA are going to get into briefly. Now, Europe has, as you might imagine, been ahead of the game. In 2016, it adopted a general data protection regulation, which said that EU employees can restrict employer access to a document simply by marking it private. And that was even, that's even applicable when it's on the employer's computer. New York State recently enacted legislation, which will go into effect May 7th, to add a new section to the civil rights law. And this is in your program materials. It requires private sector employers, regardless of size, and so long as they have a place of business in New York, to provide written notice upon hire to employees. The notice needs to say that needs to identify any electronic monitoring or interception of telephone conversations, transmissions, email, and internet access or usage. And it can be by any electronic device or system. Now, does that apply to tattleware? Probably. Does that apply when you're talking about an employee working from home? Perhaps. Notice also has to be posted, and there's some language for that notice in your materials. And the legislative history discusses the intent to limit lawsuits for invasion of privacy, because the employee is now going to be on clear notice to proceed at his or her own risk. Now, I want to share with you some stats on productivity. No data shows a decrease across the board from working remotely. The CNBC Technology Executive Council did a survey in June of 2020 that showed that 48% of respondents reported an increase in team productivity since March of 2020. 40% said that productivity remained the same, and only 12% cited a productivity decrease. Now, in the technology industry, though, 72% of executives said team workloads increased, and the perception was that everyone was working harder when working remotely. A recent study by two University of Chicago economists estimated that 37% of US jobs could be done completely from home. But according to global workplace analysts, there was the estimation that 56% of employees hold a remote working compatible job, at least to some degree. And the CNBC survey found that 68% of respondents said their remote working capabilities have improved since June of 2020. And of course, the expectation is that that's going to continue to increase. Now, to address productivity in the remote setting, consultants are now urging goal setting and managing by results rather than seats filled. So again, the shift from what has been the traditional, or at least a good degree of the traditional norm. Well, the impact on morale is also worthy of considering. According to Global Workplace Analytics, 80% of employees would like to work from home, at least partially. And there has appeared to be a correlation between the time worked at home and the increased desire for remote work. So now we're 2 years into this, and people who thought they did not want to work at home before have shifted gears and are desirous of that. Of course, issues of trust and spyware have a negative effect on employee morale. Employees seem to be particularly put off by having to clock in and out on a virtual time clock. And that's interesting to me because so many workplaces have some mechanism for recording time. And they also indicated in surveys that they resent when screenshots have to be submitted or are taken every 30 minutes. Now, what's the impact on economics? Again, I'm citing Global Workplace Analytics, and they estimate that having an employee work from home half of the time can save an employer $11,000 a year. That savings is in increased productivity, lower real estate costs, and reduced absenteeism. Now compare that $11,000 a year figure to the $7 a month figure that I gave you a few minutes ago per employee cost to monitor. All right, now issues relating to discipline for on-duty, off-premises misconduct are really the nuts and bolts of the program for the next hour. There's really little guidance because, again, this is a pretty new development. We've pieced together ideas from the general standards for disciplining employees and case law for disciplining for off-duty conduct. and apply common sense to that. But it's really a very, very much developing area of labor law. So what are some of the key issues? Theft of time and attendance, the impact that an employee's conduct has on the employer's business, whether the employee is unsuitable for continued employment due to damage to the employer's business or reputation, the effect on productivity, of course, whether there are public trust issues such as with police or teachers, and of course, that very important criterium of nexus between the employee's conduct and the legitimate business interests. So that's a very quick overview of some interesting statistics and creates a little bit of context for the discussion that we're going to move into. We'll hear first from Seth and Alyssa about what's keeping them up at night when they're thinking about employees working remotely from home. And then we're going to get into what will be the most fun part of the program, which is a discussion about some specific scenarios. Now, Anne is very kindly monitoring the chat box. So at any point, feel free to put a comment in there, but particularly while we're doing the scenarios, you may have some interesting ideas to share. So Seth, let me turn it over to you.
Great, thank you. And good afternoon, good evening. First, I want to thank Anne and Lera for hosting today's program. I want to thank Judge Cacavas for inviting me to participate on the panel. And I want to give a big thanks to Alyssa for taking the lead and really putting together the materials that allow those that need CLE to get CLE as well. So I'm honored to share this Zoom stage with these fantastic people. I only hope that I can hold my own in the discussions. So thank you. The title of today's program begins with the phrase, "When home becomes the new workplace." And although we'll touch upon this later, it is that title itself that could generate a whole discussion in and of itself. Must you work from home? Can you fly to Turks and Caicos, work from the pool or the beach, in a hotel room at the resort in which you're staying? Employee will say, if I'm productive, I'm responsive, I meet my deadlines, I provide the same or better quality of work, why shouldn't I have that ability to do so? Today's topic is really about remote working. And within that context, I think a piece of it is what is an acceptable work atmosphere. We're planning to discuss the hypotheticals or the not so hypotheticals, as the last 2 years have shown us. So I don't really want to go into a deep dive now on those specific situations. Instead, I'd just like to share some general thoughts from the union attorney perspective about remote work. Over the last 2 years, I've seen remote work issues generally arise in two contexts. First, under the umbrella of bargaining, and second, under the umbrella of discipline. From the bargaining perspective, you have the questions about whether an employer has a policy or practice that governs remote work or telecommuting. Sometimes that may be part of an alternative work schedule arrangement. So you really have to look at whether they have policies and practices pre-pandemic and how the employer is now implementing things. And then you have most situations that there isn't a policy or practice about remote working. I'm always looking to get my folks to the bargaining table on issues. And among the subjects that are implicated, previously some of them have been touched upon, but they are sign in and sign out. How is it going to be tracked? What's the obligation of the employee who may not have had to sign in, sign out before? Hours of work, not just the total hours, but the starting and ending time, the breaks. If you have flexibility, if you're able to leave for lunch and take a break, can you take that at different times? Can I start my day at 7? Take my kid to school, pick my kid up? Can I go watch TV during the day? As long as I put in the requisite number of hours and my timesheet reflects that, can I do it at night? A lot of the answers, like in almost any aspect of law as well, it depends. What's the employee's obligation to participate in audio video conferences? with their video on? Are there dress code issues? What is the expectations for responding to emails when you never had it before? Picking up phone calls. Whose equipment is being used? Is it the employers? Is it the employees? That obviously will matter later in our discussion, and as touched upon earlier by Judge Cacavas about privacy issues, monitoring issues. Are they recording this meeting's being recorded? When a supervisor has their team on a Zoom or a Teams or a WebEx meeting, is that being recorded? Can you have a background that uses filters? What's acceptable? What's in the background, right? The religious, political symbols, the signs, compensation, not just from an overtime and hours of work standpoint, but if I start working at night, do I get shift differential pay? Remember, we're talking about employees. We're not talking about independent contractors. Probably the favorite question that I get is, what if I get injured at home? Does workers' comp cover it? How I get injured matters too. A lot of people have talked about a testing policy, a weekly testing for COVID policy, not just a vaccination policy. If I'm working from home, am I subjected to that? Can the employer say it's for all employees, regardless of whether you come here or not, so you still have to go get tested? I believe that there are going to be different approaches from when the pandemic first began and everyone was home versus everyone coming back to the workplace, to a brick and mortar workplace. And now there's going to be a new policy that allows employees to put in and request working from home. What's the criteria? What jobs? Of course, we want to avoid favoritism. Employers say, well, you know, Frick is productive, but Frack's not. Well, how was that evaluated? So I think there are going to be plenty of issues at the bargaining table that we could raise. And honestly, I don't think the rules when it comes to what is a mandatory subject of bargaining have changed much in terms of what is and isn't bargainable. I think it's just the medium has. That brings me to discipline. It never ceases to amaze me how creative employees are in what they get in trouble about. But I'm equally amazed of how far supervisors also go to use remote work as an opportunity to target someone with whom they don't like, who they have a personality conflict, trying to track that employee into that gotcha moment, because obviously working remotely from home or elsewhere opens employees up to different issues that wouldn't exist if they were in the office. So what kinds of disciplines, in addition to previous issues that we've discussed? Obviously, the theft of time that was previously brought up, someone working different hours or less hours, someone plugging in certain hours of work and how you prove it, working a second job, which again, the same issues exist. Did you have an obligation to report that you had a second job as off-duty employment? Was it a notice requirement? Were you supposed to get permission? There was one instance where an employer, I have a discipline where you have an employee who sent an email back to the supervisor, but they were using their homework computer for both. And the email that got sent had the signature line, the electronic signature line of their off-duty employment, which they hadn't notified the employer about, and was obviously using that email during the day. Obviously, the employer's policy, the collective bargaining agreement, the flexibility for the employee and the job, that all plays a role in whether or not you can be disciplined, should be disciplined. We're also seeing different kinds of disciplines over what is appropriate and inappropriate on Zoom or Teams or WebEx calls. Political symbols in the background, religious symbols, kids running around. You know, you've heard about people forgetting to shut off their audio or video when they go to the bathroom, but they're also having things in the background, signs. Because you're home or remote, there's more reliance on email. And email is less formal, or at least that's what employees think. So people are using, or sending jokes. When they would have had the back and forth among colleagues, workers, they would just tell jokes or speak. There is no water cooler to go to. And so they're using work email to send jokes, sometimes off-color jokes or inappropriate jokes. Just like in the bargaining context, the standards for discipline, they haven't changed either. The rules are the same. And so we're just applying them in a different context. And I think as more and more cases don't get settled, and most cases do, but as more and more cases don't get settled, that's when you'll first see any change in those rules. But until then, I think we have the long settled principles that will continue to guide us. And I think, although I certainly defer to the judges, the ALJs, and the arbitrators who are participating to weigh in if you think that the medium matters. I don't think that it will, but I certainly would love to hear the feedback from the arbitrators out there if they disagree. And then on the specific hypotheticals, I guess we'll wait until then to do a deeper dive.
Thank you, Seth. Alyssa, you're up.
Absolutely. I want to first thank New York City Lera and Anne and Judge Cacavas and Seth for all of our lovely times together getting this done and having a good time here today and being able to talk to you all about working from home or remote work. I want to start off by saying something I don't often get a chance to say, but I agree with Seth on a lot of what he just said. Hoping he's laughing. There we go. But with that said, let's dial it back a minute. Working from home is a privilege, not a right. Because I know Seth raised a lot of issues here. It makes it seem like there's a lot of flexibility on things. But I want to start from the baseline. I think everybody with the pandemic, when we got forced into doing remote work, decided that everybody's allowed to work from home. But that's not necessarily the case. And I think with that in mind, if somebody wants to have a more flexible schedule and they want to be allowed to work from home, and a particular employer says, I want you in, I'm making it up, 5 days a week, and you don't want to go, then you don't have to work there. So with that as a baseline here, when people had an expectation of being in the office 5 days a week, then we shifted to remote work and we are coming back now. It's not as though because you did it for 2 years, you get to do it forever. And I think that's the hardest hurdle for management to convey to employees as we transition back. I think it's one of the hardest anyway. With that in mind, I know Seth touched upon some of the bargaining ideas and obligations, or what he would probably characterize as obligations. I will say that there are a lot of employers out there with wonderful, wonderful management rights clauses. And those, Jason, that's smiling again. Those management rights clauses say things like, we have the right as management to determine the manner and the means and the methods and the procedures by which work is performed, unless the collective bargaining agreement says otherwise. So I would argue that a lot of the things that you would think are negotiable, maybe not. We might have a little flexibility there. So I wanted to put that in as some background. The other pieces of this, I mean, when we're coming down to the employer's concerns, I think Seth's right. There's a lot of unknown in terms of where the expectation setting is. And if you start from the background of, or the baseline of working remotely, I won't even call it from home, working remotely should be no different than being in the office, except for the seat that you're sitting in, the desk that you're using, and the device that you're in front of, then you have a lot of baseline expectation known already. But for some reason, that kind of goes by the wayside when we're in our own other spaces and we're not necessarily having the employer sitting there checking in, coming into people's offices and things of that nature. So to the extent that employers are concerned about that, yeah, they can put together policies. I'm calling it the ABCs of WFH, work from home, right? And we go through everything from soup to nuts, like Seth had identified. There's a lot there. And there are a number of things that people could spend all evening. We need a lot more time than this to go through all the things that could be at issue there. But as a baseline, let's talk about, what happens when you're, let's say, trying to multitask, right? We've got the laundry going while we're trying to get calls done. that could be problematic because you don't get to do your laundry when you're at work, right? And so that's a good advantage for people who are working from home, but perhaps not so much for the employer who is expecting you to perform productive work while you're on working hours. Another potential issue, and that could lead to a disciplinary one, is theft of time. Laundry is part of that, but also perhaps if you think you can accomplish all that you need to do, I know Judge Cacavas put out some productivity statistics earlier. You think you can get everything you need to do done in the time allotted, but it turns out that if you had been doing just your job during the hours that you're assigned and not picking up personal calls or doing the dishes or taking care of your family or cooking dinner, you could have done a lot more work in that time, and the employer wouldn't necessarily have to or could save more money, if you will, or get more money for their time out of the employees, right? So that's another thing to consider. Accountability. There's a lot of jobs out there that have certain hours because the clients are expecting you to be available at certain hours. I mean, think of every single one of you. If you're sitting here and you want to call Optimum to get your service restored if you lose internet, you want to know that they're going to pick up the phone when you call, right? And if you have employees who are saying, oh, I don't really need to be on the at my desk from 8 to 4 because I can get the service request done between 9 to 7, that might not be the case when that 8 to 9 slot isn't being picked up. So there's a lot of organization and scheduling that needs to go on there as well. Another thing that keeps management up at night is data security, both physical and digital. Think about this. If you're using your home computer and you've got other family members that use that computer, there might be confidential work data stored on there that's not properly secured. Or let's say your computer gets hacked. What are we going to do then, right? Because the employer is not sitting there managing your daily or weekly, whatever setting you have it on, updates to ensure that all the security protocols are being updated every time there's another gap in the Windows security software or Apple security software. You're not sitting there making sure that when the iOS 15.1.3.4 comes out, we're updating right away because it has a security patch, but it might make you lose Bluetooth and you want to wait a minute. So there are a bunch of things that go on there. You also have the physical files. There are things that are confidential that you might be dealing with that really do need to be properly destroyed or shred, and you might not have those technologies or capabilities at home. So you have to prepare and plan for that as well. To move a little bit further on, there's tech competence, or incompetence for that matter. I think you've all seen the I am not a cat video. You can't, well, you probably can't micromanage how competent every single one of your employees who wants to work from home is with technology. And so when the first time they say, I couldn't figure out how to unmute myself for Zoom, okay, you train them. The second, the third, the fourth, it might start to seem like it's a little intentional, right? Or I couldn't figure out how to get my camera on, or I don't know how to get into this particular software. So that becomes problematic as well. And when you're not physically in the office, there is less of an ability for somebody to sit there, go onto your computer and say, okay, I'm going to manipulate this. I'm going to show you here. Yes, there is the share screen function, but you also have to have the ability on the employee side to click yes and give them the code. So it's not foolproof there either. What else? 1 second, guys. Hi, Mom. Yes, I'm giving a speech. Yes, Dad is watching. I've got to go now, okay? All right, love you, bye. Exhibit A. That's a problem. Love my mother, but busy, right? Now, of course, I wouldn't normally pick up if it wasn't so perfectly timed for this presentation, but there you go. You have a lot of distractions when you're at home, and those distractions can interfere as well. Now, how many of you in the audience have an Alexa, a smart TV, a Hey Siri enabled on your phone? Any of that? I probably just set off a bunch of your devices at home because I said Alexa. Okay. They're always listening. And if you don't take the precautions to actually turn off those settings, it's going to be listening to all of your work conversations. It's going to be transmitting data. And it's almost like a hidden technology faux pas. You want to make sure that you can control those kinds of things. And you can't because the employer is not in every single person's home. And I will leave it at this. I think as a broad concept, we haven't really reinvented the wheel here. People have been working from home for a long time, or working remotely. There are Newsday articles where somebody who's on this Zoom was working from the beach, and people thought that was hysterical. So it got written up, okay? That is not new. What I think is new is the employer and the employees both paying attention to the nuances of doing it and the rights and responsibilities and obligations of how this all gets done. So from that perspective, I think there's a lot that can be done, and there's a lot to be done to plan as we transition to being more regulated and frequently using remote work. And with that, I will end my monologue.
Okay, thank you, Alyssa.
Elena, I'm sorry, just before we go any further, I do have to give the first code word, and that is EBG, elephant, boy, girl, 282. EBG, elephant, boy, girl, 282. Okay, thank you. Sorry about that.
No problem. Thank you. Thank you, Alyssa and Seth. Such great points you raise and such interesting perspectives. All right, we're going to move into specific scenarios. Some of these are actually things that happened, although I'm not going to tell you which ones are. But, you know, as we go through them, Anne, you let us know if there are comments or questions in the chat that are applicable to them. So let's take a first scenario. An employee's on a Zoom and there's something offensive in the background. So let's start with something like objectively offensive, like pornography or, you know, drugs or a bong. Okay, so what are the implications of that? Alyssa?
I'll start with, can you have any of those things in the background in your office? Then you can't have them at home. I think you're looking at the issues with how other people in your workplace, your virtual workplace will react, potentially if you're having client meetings, how those individuals will react. And I think that there is a very simple workaround to that issue, which is that the employers can implement background related, criteria or base, I'm trying to use a different word here, like a Zoom background that's meant for the company that you have to have activated at all times. The only potential technological issue with that is some computers, if they're old, really old, like one of my laptops, it can't run backgrounds because it doesn't have that functionality. But then it's on the employer, I think, to make sure that the employees provided with what they needed so they can run that mandatory background.
Okay, Seth?
So look, I think if the employer is providing you with a laptop or a computer, they have the software to be able to put filters, you're not going to have an issue. In terms of if you can't have it in your office, you can't have it in your home. I think that's too simplistic. Obviously, you have to use discretion in terms of trying to move things out of sight. But at the same time, you know, some people work in a 1-bedroom apartment and they have limited space, and you know, if you first, of course, I would say, well, what is it that we're talking about, right? Are we talking about, like, is it porn, like a television in the background? Is it artwork that someone is offended by and that, you know, may objectively not be? Is it, there's a magazine that a teenage kid left on the kitchen table that someone can zoom in and see? And so there, is it that gotcha? From a drugs and alcohol or, standpoint, or from drugs, is it paraphernalia? Paraphernalia that is legal. It's not being used. They're not using the drug on, I think that's much different. I think porn is a lot easier to say it's a no-no, but I think having paraphernalia around is much different. And I also think I would use alcohol as an example as well. If you have an open beer can or bottle, or an open bottle of vodka sitting on the screen, and you're drinking, that's one thing. But if in the background at the kitchen table there are groceries and there's a 6-pack of beer, I think that's much different. So I think context matters. generally I say, like, employees should be smart enough to put that filter on if they can. And if they have that ability and they don't, I think that's different than if they don't have that ability. But generally, yes, porn is a no-no. Doing drugs or drinking alcohol at work is a no-no. But I think just basically having certain paraphernalia, if the employer provides that filter, fine. If they don't, I think there's got to be some level of flexibility depending on the circumstance.
Okay, now Seth, does your answer change about the paraphernalia if you're dealing with an employee in a position of public trust, a teacher, a lawmaker, a police officer?
Yes. Teachers, police officers, they're held to a higher standard. They deal with the most vulnerable in our society, obviously. And so they deal with the mentally aided, they deal with children, they deal with the public. It's much different. And again, it's no different than the analogies that we would do with any other discipline in terms of if you have a custodial staff that works the night shift in a data entry facility, doing something versus a police officer, a teacher. Obviously, I think the standard is different and it continues to be.
I
Okay,
have a different question for Seth. If the bong was in the background of your employee's Zoom meeting with a client on the other side, would you feel the same way?
If there's simply behind my employee in my work, or there's a client there.
There's a client on a Zoom. You've got
I think that's the point. I think there's a difference between a supervisor having like a team meeting and you're engaging with the public or whoever your client is. I think that also matters. And I think that would be a mitigating factor to consider.
Okay, now make it a little bit harder. So, a bong or porn is objectively offensive. There's a good argument for that, right? But recognizing that some offensive may be in the eyes of the beholder, what if you have an employee, and this gets into, freedom of expression, who in the background has a poster on legalization of marijuana or abortion, or has Fox or CNN on in the background? What's your reaction to that, Alyssa?
I mean, I continue to think that while you have the right to have your own freedom of speech in your own private space, once you've blended your work and your home life, there is a level that has to be met here to be appropriate in the workplace. What you have in the background of your Zoom screen might actually offend a client. It might offend, you can't have that up, as Seth had mentioned, in a different context when you're a teacher. You need to have some level of decorum. And I think that I'll go back to what I started this with. Work from home is a privilege, not a right. And if you don't have a space in which it's appropriate to conduct your business without these borderline wall hangings, if you will, you either have to move the space that you're working in, or you need to find some way to mitigate it.
Seth, do you have any opinions on this less objective offensive?
Yeah, again, like anything else, I think it depends. If you have an employee who at their office has a file cabinet and they can and you allow in their office, allow bumper stickers that say certain things on it, I would throw the same question that Alyssa threw to me back at her. If it's acceptable in the workplace to have those same signs and bumper stickers, then it would be acceptable at home to have it as well. And again, I do differentiate between if it's simply employees that are having this meeting on a Zoom, let's say, for example, or a teacher teaching to students having something in the background. So I think that, again, like everything else, it depends. Obviously, Alyssa and I are intentionally taking opposite approaches. Although we probably agree on 95% of this in actuality, but I think it matters. Yeah.
Anne, are there any comments in the chat that relate to that scenario?
Yes, there's a question. What if it was a cross with Jesus realistically depicted, or a menorah, or a Muslim symbol, or a Puerto Rican flag?
Alyssa, any changed perspective on that?
I mean, not really, but I don't think that those things are things that are objectionably offensive. So I'm not sure that it's necessarily analogous. I mean, I've been in high school classrooms where they've had all sorts of religious symbols and other types of things hung up on the walls there. So I'm not so sure that's going to be an issue if there's a, you know, the right to put a menorah on your, not menorah, a mezuzah on your office door. I don't see the problem with putting one on the door of your personal home.
Seth?
There certainly is no problem putting it on the door of your personal home. Again, everything is fixed by that filter behind you, right, in your meeting. I think really the issues come up, it's less about the religious than it is about something that is more divisive, like political issues, right? Someone has a MAGA hat, or someone said, you know, has a, you know, Biden for president hat, or someone has a Let's Go Brandon poster behind them, by way of example. So, you know, if you have the filter, it's easy. If you don't, I think the circumstances depend. I think you're going to have to evaluate based upon each situation, who they're on a Zoom with, what, you know, who else is there. If it's just with your supervisor, I think context matters. I think it always has. So.
Elena, another question. The employee is disciplined for the same issue, but the context and the fact situations are totally different. What would the argument be for or against using the first level of discipline as a predicate to enhance the discipline the second time?
Alyssa?
I'm not so sure I understand that question. I
Yeah.
apologize, but
If this person could please clarify in the chat, because I also am having a little bit of difficulty understanding the question. I'll move on to the next one in the meantime. Isn't the question whether or not employer can mandate a certain background be used so these problems are avoided?
I mean, yeah, I think that's pretty well settled, though, you know, especially if the employer is providing the equipment. And I would argue, even if not, as long as the employee has the technology to implement the background, I think they have the right to mandate that they do so. It's basically the remote office environment.
I think it goes back
agree.
to your position, Alyssa, that, you know, it's not a right. It's an opportunity or a privilege or whatever, you know, term you want to apply to it. But certainly, I think we'll see that employers are anticipating these issues more and exercising their rights to do something like that, which is an easy solution to what could be a very complicated issue with clients.
Can I just add, I think a lot of the questions are always this, you know, come back to, a lot of the issues can be resolved by answering two questions, right? Is there a policy or rule about this? And has the employee been trained upon it? And I think those answers also help dictate, going back to the question we think was asked that Anne had mentioned, which is, you know, if there was no policy and there was no training, then, you know, the various different progressive disciplines, it's kind of like, okay, well now, you know, I'm just going to advise you that this is, you know, it's an inappropriate thing to have, but they don't get in trouble for it the first time, right? But in the absence of having a policy and in the absence of training, those are two tools that I'm going to use to defend an employee who's being brought up on disciplinary charges.
But I think there's a level of common sense that has to be applied there too. I don't think we need a policy and a training not to wear pajama pants underneath your work blouse when you're sitting at your desk during work hours. I mean, when the employee then stands up to go get something from the back of the room and you see that they're wearing tighty whities, you know, you don't need a policy and training on don't wear tighty whities as your bottoms. You know, there's a little bit more to it than I think what you're letting on to.
Agreed.
All right, let's go to the.
Elena, sorry, just a clarification, I guess, of that original question. I believe it's saying that if there's a second instance of an inappropriate background, but with different facts, would it be a first or a second discipline? So somebody does something with an inappropriate background, they do it again, but something else is in the appropriate background. Would that be a first or second discipline?
Well, I think the underlying concept is here, your background was inappropriate. Here are the reasons why. Please don't do that again, employee. And then the employee says, oh, okay, so I'll just swap out this offensive thing for that offensive thing. And I think it's a new scenario. I would argue no.
Yeah, I agree with you.
Yep, I agree, except if there was porn in the first instance and a religious symbol or a MAGA hat in the second, because then it's not repeating the same thing.
I agree with that, Seth. I think the analysis would go to the degree of difference, but clearly there's been notice that you have to be careful about what's in your background. But the example you give is, the employee may very well say and be believable, well, you know what, I understand the porn thing, but I didn't think my MAGA hat, which I love, is going to offend anybody. Let's go to the scenario I raised when I was speaking in Saratoga. You've got an employee, a good employee, who's bragging that he's getting to the gym 2 hours a day when he should be working, and then he does his work at night. Is that a problem to you, Alyssa?
I would think so. I don't get to go to the gym in the middle of the day if I want to. And I think and I'm saying that as the perspective of another employee, let's say. And I think that while I think Seth will argue if you can get your work done in the time allotted, et cetera, you should be allowed to go to the gym. Good for you. I would take the opposite perspective and say, for one, we've got clients who have an expectation of you being available during certain hours. So skipping out and going to the gym, not so good. And two is if you can get all that work done in whatever period of time that was, imagine what you could get done if you weren't at the gym.
So it could very well be a problem, or it could be no problem at all. If I'm an employee that has specific hours that I have to work 9 to 5 and I have a 1 hour lunch and a 15-minute break or half-hour break, if I was always allowed to, if I could, for that hour and that 15-20 minute, I can get to the gym, or I could go to my home gym or do whatever it is, I don't think it's a problem. Because I was always allowed to do that before. You didn't control me during that lunch hour or that break. If I have specific hours and I have flexibility of when I go to lunch or the amount of time, I have an 8-hour work day, but I'm only I have an hour and a half, and I have flexibility, and I always did. I could have not taken lunch when I was in the workplace and then left an hour and a half early. Then you know what? They could take that hour and a half however they want. If that's what the rule was, if that's what the practice was, then that continues. So I think it really goes back to what was that individual's hours, what were the terms and conditions of that employment under the collective bargaining agreement or for that job title. Because my time is my time. If I was able to leave to go to lunch and I went to the gym before, why can't I do that now?
And I totally agree with that, but why would they be bragging about going to the gym now if they could do it before? I mean, I think inherent in the way the question was set up is that this is something they could do that they wouldn't have otherwise been able to do if they were working from the office. So I don't think you're in the situation where, they could have had that flexibility. They could have dipped out, gone to the gym, came back, taken a shower, whatever, and got back to work. That's not what we have here. We have, I'm working from home. So since I'm going to be, over dramatic, since I'm not being watched all the time, nobody's checking on me, I'll go take 2 hours, go to the gym, come back, and then I'll do my work later tonight. No big deal.
Right. Maybe it's not an hour break or an hour and a half combined with break time and lunch, but it's 2 hours in the middle of the afternoon. Now, Seth, would your answer change if let's say there's no rule in place about second jobs, and the employee is again doing the same amount of work, but has a dog grooming business that works better during the day? So the person's taking a few hours out of the middle of the day to do dog grooming and then making up the time at night.
If my obligation is to put in a certain number of hours a day without regard to starting and ending time, then my answer wouldn't be the same, right? Like it would be the same. That as long as you get it done, that's all that matters. If your obligation is to work a certain number of hours, then yeah, of course, that's a problem. It's a problem to do, to work a second job during the hours in which your first job is scheduled. And, the mitigating factors that I would point to is, are they being responsive? Are they getting the work done? But that's mitigating the problem. That's not excusing it.
Alyssa, anything you want to say on that scenario?
I'll just add that you see it happen all the time. There's a big snowstorm and you've got people who have trucks with plows, and all of a sudden they can't make it into work on time for whatever reason, even though they've got the truck with the plow. It's probably because they're doing what I would call the side hustle and plowing for a few extra bucks. And I still think that you've got to balance your employer's right to have you come in when you need to come in. I know Seth's example was you've got flexible hours, but more often than not, your hours aren't as flexible as you think they are unless you're, one of us who works 24/7, 365. You really have an obligation to be there when the employer expects you to be there. And if you're not going to be there, oftentimes in any other scenario, you'd be using paid time off to cover that gap time. So
what if, and we'll change the scenario slightly, what if I don't have a second job, but I decide, you said, your obligation is to be responsive. What if I'm able to answer the phone? What if I can send on my device, respond to the emails? What if I have a job that I'm sitting and waiting for stuff, and I don't have 100 things to do. I answer phones. I respond, I forward on emails. I respond to emails, but I'm still able to do it. I get the ding on my phone, and I answer every phone call when it comes in, and I have all the answers, and I send every text. I respond to every text message, and I respond to every email. Does it matter?
I would say fine, then you need to clock in and out every single time you stop to do your side hustle, and then you stop to do the work for the employer, because I don't want to pay for the time that you're spending doing dog grooming.
But when I was in the workplace, you didn't have a problem with me answering calls from my children, my wife, my friend. I was sitting at the office, but I was answering phone calls. I was texting with friends. I went over to the water cooler. You didn't have a problem with that. I didn't have to log out and log in every time I did that. Why is this any different?
Sounds like we need a policy change. Just kidding.
Or maybe we need to sit and negotiate.
I mean, look, I think there's a distinction to be made to be fair. I think there's a distinction to be made to be paying you to do a job, some other job, versus taking the intermittent personal call. I mean, the personal calls exist. That those are a fact of life. You just saw, my mom calling in the middle of something important. But you've got a difference between that and I'm paying you to sit there and do another job.
I agree with that, but that also means I should be able to go to the gym for the hour and a half that I'm on my break or I'm at lunch, because it's not the second job. I can do what I want on that.
You are on break. I completely agree. But why are you bragging that you're going to the gym on your break unless you need people?
Because I don't have to travel anymore. It's like right here. It's like across the street from my apartment.
I mean,
don't
if you got that great Bowflex and you want to
get
some extra cash.
I get an extra. I used to only be able to go for an hour, and now I can go for 2. Clearly, I don't go at all. But for those that actually go to the gym, it affords them greater flexibility.
Okay, now let me ask another scenario. So forget about a virtual background. You have an employee who isn't smart enough to think about that and is participating in a meeting from a place that is really perhaps not appropriate, poolside, or sitting on his or her bed. I've actually had witnesses testifying while they're sitting on their beds. Your reaction, Alyssa?
There's a level of professionalism that's generally expected. If you couldn't sit on a bed in your office, you probably can't sit on a bed at home. That would be where I'm coming from on this. Poolside, I have less of a problem about, actually. I think that if you can properly conduct your business and you're not, if you're in your bathing suit, I think it's one thing. But if you happen to just be literally sitting poolside and you've got a desk set up and you can do what you need to do, I have less of an issue with that. I think it's really about making sure that you have set the expectations for your employees as to what isn't okay, to get to Seth's point about policies, but common sense applies. If you're in your pajamas while you're supposed to be working because you're in bed, maybe. So
if I could go poolside, do you care that I'm out of state? Do
No.
you care?
I mean, unless your license requires you to be in state to do whatever you're doing, I don't think that's as much of an issue anymore. There are other ancillary issues with that in terms of the employees and whether they're paying taxes to work from a certain location, that they owe taxes to do 2 different states now, and all that other kind of stuff. So it's more, I think, an employee issue than an employer one, unless the employee can't do what they need to do from wherever that place is.
So what about the implications? Let's talk about the implications for things like leave time, right? And leave accruals. So, you know, you have an employee who decides that he or she's working remotely from Long Island. So why not go to Colorado for the week and work remotely from Colorado? Now, in any other context, the person would have to be taking vacation time, right, to do that. But they're not. They're not using their vacation accrual, but they are out of state and away. And maybe they use their lunch hour to go skiing.
I would say in any other context, though, they wouldn't be working from Colorado. Right? If you're
But that shouldn't matter, right? Because if I go to the West Coast and I'm on the East Coast, it's 3 hours earlier. I decide I'm going to sit in the hotel room for the 7 or 8 hours I got to work that day, and as early in the morning. And when I'm done at 2 o'clock in the afternoon, I'm going, I'm going out.
I completely agree. I'm saying that you wouldn't be using PTO. I mean, you would be using PTO in the other context because you wouldn't be, or vacation time, because you wouldn't, in theory, be working wherever you were. If you're working remotely, I think work is work. And I mean, my perspective, and I think originally there was a generational comment made in the intro of this, but my perspective is if you can do it within the employer's guidelines and expectations and be productive and be reliable and be accountable, I don't think it physically matters where you are. I mean, that's just my take on it. I've remotely worked my entire career. Not 24/7, but enough.
Does that mean that employers will see a surge in the accrual and vacation accruals or sick time because now an employee doesn't have to take 3 hours of sick time to go to a doctor's appointment?
I think it's a balancing act. I mean, some employers have use it or lose it policies. So to that extent, maybe not. But if you're getting that much more work out of your employees, yeah, maybe the accruals will start to, accrue, for lack of or add up. But then it's a matter of, well, if they're not using their time, they're working. And if they're expecting a payout, I hope it's in their policy or collective bargaining agreement or what have you, because it's not guaranteed otherwise.
Using the sick analogy, I don't feel good enough to go into the office to make the trip in and whatnot. But I could sit home. I don't want to get anybody else sick either, right? Like especially now with, in COVID, employers say, stay home, right? We'd rather you be careful. Don't bring it in here. Now that masks are gone and apparently COVID's over, then, we should but if you have sniffles, you're not feeling good, don't come in. So I said, okay, I'm not feeling that great. I'm happy. Nope, stay home. But I don't want to use a sick day. I'm happy to work from home. You say yay or nay. And what happens if Johnny says the same thing, but you say, Johnny's, is it going to now, what does Johnny do versus what Seth does? How productive Johnny is as a supervisor? This goes into what are the rules? What are the criteria? Who's allowed to do that? How often are you allowed to use your sick, that you're sick, that not have to use a sick day and be able to work from home?
I think those are all valid points, but I think that then you get into a few things, one of which is I still stand by work is work. And, employers, it's a benefit, I think, to some extent, if somebody is not well. I mean, we've seen this with COVID in particular, even if you're feeling okay, but you've been exposed in some instances, employers don't want you in just until you've had enough time to incubate and see if you're going to test positive, because sometimes you're asymptomatic. I mean, if you can perform.
And if you're going to cover my time without charge to my leave accruals, I'm happy to stay home.
Are you working?
If you want to tell me to stay home and you're going to cover it, great. If you say, no, I want to come in, you say, no, you're not feeling 100%, then, I'll work from home if you allow me without charge to my leave accruals.
I mean, I hear you, but I think when you're in the same breath, if you're taking out 3-4 hours, sometimes you have to wait a long time to go to the doctor in the middle of the day, you're using your sick time to go to the doctor because you aren't working, right? But then you get into, like you said, Seth, there's, person A, employee A is a good remote worker, knows how to get things done when they're working remotely, and employee B might not be. Then you've either got to set expectations in terms of how to do better next time, and perhaps that person loses that privilege to be able to work from home if they're not able to effectively do it, and they've demonstrated more than once that they're not efficient when they're home.
Keep in mind that statistic that I mentioned, the estimate that $11,000 per employee is saved in decreased absenteeism by allowing remote work. And, that probably goes, in, at least in large part, to the idea of somebody who is too sick to get dressed and get out of the house, but able to work from home. Seth, let me ask you how you defend the employee who puts a stapler on the space bar to stay signed in.
The employees I represent would never do that. So I don't have to address that issue. Look, I think it, again, I hate to say it depends. I mean, how do you defend an employee who sits at a meeting that's an hour and just kind of dozes off, right? Is that, do they have to actively participate? Are they listening? What's happening there? Are they engaged in is it a meeting? Is it, I don't want to hold on to the space bar, right? So
I will say, for those of you who are looking to use that trick, for the employers who spring for the slightly better than the lowest level of software, it actually monitors that you're using different keys when you're doing keystroke logging. So leaving it on the space bar will keep you signed in, for example, and won't have you your computer go to sleep. But the employer will still know that you're just hitting space or one key.
Now, what about the employee who says, you know what, I'm working from home, my kids are well behaved, I'm going to get rid of my babysitter. So, the children are in the background during a meeting. Does it matter if they're disruptive or not? Is there an issue with, again, double duty of babysitting and at the same time working? Alyssa?
I mean, look, I have a lot of respect for people who are trying to manage kids while working from home. I did not have to do that, but during the pandemic, you saw many, many, many people who did. And, kudos to you if you're able to get it done. But I think taking the employer management perspective on all of this, it's the same mantra. Work is work is work. And if you're too distracted to get your work done, it's going to be a problem. If your kids are having to be home, let's say they're in high school and they don't need to be managed and you don't need to watch them 24/7, but they're sitting upstairs and you're working in your home office, that might not be a problem. But if you've got an infant at home and every few hours, instead of doing your work, you've got to go tend to the infant, I mean, that might become more problematic if the employer's paying you for that time.
On the other hand, it could be that you're giving, you have an employee that you want to, you don't want to take childcare leave for a period of time, right? Or FMLA type stuff. And you're granting an accommodation to them to work from home, knowing the circumstance of having a kid or family member or others at home. In that instance, the employer's accepting that there may be distractions. And as long as that's known ahead of time, I think it would be difficult for you to take action against the employee when you knowingly approved a work from home situation with those circumstances.
I would agree with that.
I mean, obviously the level of distraction matters. And, when we were discussing this beforehand, and for those that are listening, there's a big difference between March of 2020 through, in those 6 months to a year later and today. I think employers and employees had a certain level of flexibility then under those circumstances. What you do still see in some places, although most places kids are back in school full time, but there are circumstances where it's not available yet. And I think forget about the legal obligation for a second. I think the circumstances do matter, and the reason why they're home, the reason why their kid is home. I think it would be good for morale, and certainly not precedent setting, depending on the circumstances, which really leads into one of the things that we haven't discussed is what's the criteria, assuming everyone's back in a brick and mortar workplace. And now there's a policy that the employer is just gonna kind of say, look, I'll allow, if people want, You can put in an application like an alternative work schedule to work, work from home, right? Ordinarily, you would say, I want to work same hours in 4 days, or I want a different starting and ending time. Now I'd like the ability to work from home 1 day, 2 days, 3 days, 5 days a week, whatever it may be. One of the issues is, what's the criteria? And does it have to be objective? Does it have to be subjective? Does it matter, what your role is?
Well, I think that, the real tangle is going to come trying to differentiate or justify giving, the accommodation of working remotely to the good employees and, not for those who've shown themselves to be less productive. Can you do that without getting sued? I mean, Alyssa, what do you say?
I think, so I never encourage any of my clients to do it that way, but I think you start with everybody. If you're allowing remote work, everybody is allowed to do it until you've proven yourself no longer to be allowed. If you've engaged in enough misconduct or you're not productive or what have you, it's not going to be a discrimination type issue. If you've got a legitimate business reason or a demonstrated discipline issue that's resulted in you losing the remote work privilege. And that's where I would come from this.
Do you go, so let's say you have the employee who has an abysmal attendance record and has had issues on the job of, poor performance. Does that person begin from the platform of everybody gets the privilege and you have to lose it? Or is that person not going to get it to begin with?
I think that's a client call, because either way I make a nice chunk of change dealing with it. Just kidding.
Well, Seth, go ahead, Ann.
Sorry, time for a code. So the next CLE code is LER, Lion, Elephant, Robert, 222. LER, Lion, Elephant, Robert, 222. Okay, and we do have a few questions. I don't want to miss them in the chat. So would you like me to?
And actually, before we get into those questions, there's one last thing I think we wanted to touch on, but before we get into those, and that's something I thought Seth was going to bring up earlier, but it's a mutual concern on the employer side. There's employee burnout for being so on call or at home working in the same spot 24/7, 365. And on the employee side, there's the loss of that work-life balance. And that's part of where I think remote work is actually a double-edged sword. If you're constantly able to work from anywhere and that becomes the expectation that you don't get to take that week off to go to Colorado because everybody expects you to be available to work. And I think that's something else that employers and employees need to consider when thinking about remote work. I think this is all going to be a cycle, just like tie-dye. We're going to all be into it for a little while, and then people are going to realize it's not that great and start to dial it back again.
Interesting.
Right. So one of the questions that is in the chat is, what are your thoughts on discipline or hot mic type of situations? In other words, the employee says or does something inappropriate, offensive, or unprofessional when they clearly believe the camera or mic is off or they have left the meeting. Example, employee says aloud, "This presentation is so expletive boring. This meeting is expletive waste of time."
I mean, my first response is, I'm sorry we didn't engage you better. Look, it's no different, right? Then you're in a workplace and you make a comment that's inappropriate. Again, I know that the facts and circumstances and situations that we're seeing are different, but I think that the analysis is probably the same.
But it is a little bit different in a workplace. If you're sitting in a meeting and you say, this meeting's terrible, or the supervisor's, stupid, or whatever, you say it, I think, with the expectation that it could be overheard. The scenario that I think the question goes to is, somebody says it, and again, this gets into technology and differing levels of comfort, and there's no expectation that anybody but the dog is going to hear it. And, and it's broadcast to the whole audience that's involved in the meeting.
I analogize it though to, like, there's a meeting and I go to the bathroom and I'm in the restroom, and my expectation is that the comment I'm making to a colleague, or I walk in, I'm like, oh man, that was awful. I don't have an expectation. I'm at work, but I don't have an expectation that someone's going to overhear it. Now I forgot to turn it off. I mean, do you see that as the same or something different?
What I see is the difference, I guess, a question of intent. You know, I view the person who's sitting in a meeting at work to make a statement rather intentionally, or at least more intentionally than sitting at home, you know, in his office, and the mic just happens to be on. I mean, analogize it to, you know, an employee who is testifying before the NLRB and doesn't realize the mic is on and says something, you know, derogatory. I mean, I think, you know, all of these issues go to degree, right? And they're very fact specific. Alyssa, what is your sense about that?
I happen to be in the same position as Seth on this one. And I think by way of example, if the comment, regardless of the intent of being overheard, if the comment is something so egregious, it doesn't matter if you intended it. Ignorance of the law is no excuse, as you know, as another example, ignorance of the ability to properly use technology in my perspective is no excuse here either. If you're saying that person is a bleep, it doesn't matter if you intended that person to hear it or not. If it's something racist, if it's something sexist, you're still going to be, I would advise my employers to discipline the person for that conduct. It doesn't matter that you didn't intend for them to hear it. You said it.
Yeah, I just think the difference is, you know, there'd be mitigating factors in the context in which you did it, you know, how severe, you know, how severe the consequences would be.
Well,
Yeah.
what about the employee who thinks that he or she has a screen up and it fails, and there's something offensive or embarrassing that, you know, 200 people who are on a conference call see? Do you hold that?
Before we get to that, sorry, Seth does have to log off. He's very in demand this evening.
Mhm.
So we promised him that it would be okay if he logged off 10 minutes before the end. So Seth, thank you very much. We appreciate your being on, and nobody else log off because we're still continuing. Okay.
Thank you so much. I appreciate the opportunity. Thank you, Judge and Alyssa. Take
Thanks,
care.
Seth. It's been fun.
Thanks, Seth.
So Alyssa, how do you treat that differently?
Look, I think I would say that this is the same analysis here, but when you're dealing with failing technology versus the inability to properly use it, I think there's a distinction there. I think everybody's entitled to proper training, but when something is beyond your control, there might be a desire to have a little more leeway. But I also think it's going to depend on the impact on the employer. If that screen failing resulted in somebody's naked parent or spouse walking around in the background and it caused some kind of major backlash, that might be treated differently than the screen failed and you've got a bong in the background and you notice it happened and you put something right back up.
Mm-hmm. Do you hold an employee accountable? So the employee is working from home, has been working from home for quite a bit of time. There's a very important meeting. The employee is aware of that with a high profile client, a big account, and the employee miscalculates the time difference and misses the meeting.
I mean, I would treat that the same way as when somebody misses a teleconference or when somebody misses an in-person meeting, that you failed to properly set your iPhone to the right time to give you an alarm to log on. I would not have a lot of sympathy for that.
And you want any questions in the
Yeah,
chat?
I have a couple more questions. And I guess, Elena, this is for you. It's asking if any arbitrators have dealt with issues regarding these type of issues regarding misconduct while working at home. Has that come up yet in any of your arbitrations?
I've had 2 cases and they both settled out. One dealt with something inappropriate, objectively pretty inappropriate in the background. So it's not surprising that that it's settled. And the other dealt with an employee who was to be working from home, presumed to be at home on Long Island, and was actually on a vacation, in that case in Hawaii. But they both
They posted on Facebook, right, and got caught.
exactly, actually, yeah.
Yeah, sounds right.
And the other one is, based on the discussion thus far, it seems employers are prone to issue policies or negotiate rules pertaining to working from home to address accountability. Is this something the panelists see as an evolving trend, or are employers using previous policies?
I think you have to address it on a case-by-case basis. I mean, some employers were already a little more progressive when it came to remote work, especially with respect to bring your own device policies and things like that, when people started using their own cell phones and tablets for work. When you have that already set up, you might not need as much of a lift to get everybody on the same page. But I also have employers who are saying, I don't want to develop new policies about this. We're going to have a meeting. We're going to talk about, what's going on and what you're allowed to do and what you're not allowed to do. And that's our expectation setting. And if you fail to adhere to it, we're going to proceed from there.
In the European countries, in the EU, there's been a lot of movement toward negotiating. They've been ahead of the time with this remote work. And so remote work issues are really very common now, negotiated in the collective bargaining agreements. And I think that employers, if they have policies in place, would be foolish to just discard those. I think what we've been talking about for the past hour is that it really is an issue of tweaking the traditional rules or the traditional analysis to fit this kind of new situation. And although some of the issues may not be new, the context is certainly different. And I think the volume of the application is what's going to really drive employers to think about creating policies or think about taking things to the negotiations table. I mean, I've seen in mediations that COVID has led to, significant negotiation about contract language to avoid situations that arose in the past 2 years. So I think employers will use policies that have worked, but they have to be tweaked. It's a little bit different situation than it's been.
Any other questions that anybody wants to put into the chat? I guess I have a question, because it seems to me that when you're in the workplace, there's a lot of objective criteria because you're in the workplace, right? You have an office, you have a desk, you have expectations, people see you come, they see you go. I think that, and I don't know if this is a statement or a question, but it seems that when people are at home, it all becomes very subjective. Because in the answers to all your questions so far, it's all sounds, very much subjective. Is there any way to bring objectivity to the remote workplace? Because I guess you can't, the oversight is not the same as it is in an office.
I think it's very different. I think it's really a fascinating development in labor. I think that the way you bring continuity or objectivity, and continuity in terms of rules or objectivity, is by developing policies. And I see us at, I don't see us at the end of the issue. I don't see us at the middle of the issue, despite having been in it 2 years. I see us as an industry very much at the beginning of the process. And I think that over the next 10 years, how I think working remotely is here to stay. And I think how it shakes out is going to be fascinating to watch. And I think that the only way you get objectivity is creating some of the types of standards that we've been talking about. But, we've opened up a whole new set of facts, right? Everything is just operating in a very different context. Same rules we're going to try to apply, but really a different context, and a context that's much more open to issues.
I would agree with that. I think to the extent beyond what the judge has already said, to the extent that there's objective criteria that have existed and will continue to exist, they come in the form of output. They come in the form of the parameters of work productivity and expectations that have already been set, no matter where you are. If you've got X widgets you need to make sure you email out by 5 p.m. every Friday, that's your objective criteria. If you can do it remotely, great. If you can't, then we either need to find a way to make you able to do it, or you might not be able to work remotely anymore.
We have a comment in the chat. Dan Dashman said, I think the policy that is where there is conflict has been the idea of doubling. Alyssa referred to it as stealing time, and Seth saw it as using time well. Management has to talk to the union about what the line will look like.
I think that's very, very true, Dan. I think that, and you know, it kind of goes back in my mind to this traditional concept of what an employee is expected to do and where an employee is expected to be. And this new kind of revolutionary widespread acceptance that work can be done in a whole different place than we've always said. You know, it's again, that transition from counting bodies and seats to measuring performance and accountability by different standards. And we're still seeing those standards evolve, but I do think that management is going to have to talk with labor to figure out the lines.
Alyssa, any final words?
Just thank you for taking the time to listen to me and to Seth and to the judge and to you, Ann. I think there's a lot of stuff that's going on. Some of it's new, some of it's not. And one of the things we didn't dive too deeply into, and I'm thankful for it, is the comments about the generational gap, because quite frankly, I think that while there might be more of a norm for people who have lived the remote life their whole career, that fact alone doesn't make it the only way to be, or the only way to conduct business in the future. And I think everybody's got to take a minute, evaluate what works for which environments, and then go from there. We don't need to jump into the pool so quickly. We can actually make this work by working together.
So I agree with that. So I would like at this point just to remind people, if you weren't on at the beginning, if you would like CLE, please put your email in the chat. Tomorrow, I will be emailing out the materials to everybody who attended, and I will also be emailing out the forms for CLE to those of you who have put that information in the chat. The other thing I'd like to say is I'd like to thank Elena and Alyssa and Seth, even though he's left, for a wonderful presentation this evening. I think they brought up a lot of interesting points, but I also think it would be very interesting if we actually repeated this program in 1 year from now, because I think we might have a lot of different answers to that question. So I'm going to put that in my back pocket. I won't be the president of Lera, but I'm going to suggest it next spring, because I think we might all come back with some very different perspectives. So at this point, I want to thank everybody for attending, and we will let you know when our next program is. And thank you very much to the presenters.
Thank you.
Have
Thanks.
a great night, everybody. Stay safe.
Okay, and Bernadette, if you can keep this going for a minute, because a number of people are still putting their emails into the chat, please.
Absolutely.
Thank you, everybody.
And